That's okay. Okay.
Okay. All right. Okay. I might need to keep on pressing the admit for the students to come in.
Yeah,
Okay.
correct. Mm.
Okay. Hi, Cindy. Hi, Paul. Okay. All right. Okay. First of all, good evening to all the students here. Okay, I will actually like to take this opportunity to thank our Dr. Chi for organizing these wonderful sessions for all the CLP students here. So for today's topic, we are going to cover the civil procedure, especially on the topic of enforcement of judgment. Okay, I will assume that all the students are quite familiar with the types of enforcement itself, the orders, and also the case law. So we'll focus more on how to actually tackle the question by going through the past year question. Okay. And to be very honest, I'm not doing any lectures or classes for any universities. And this will be my first round for this type of classes. So, and there's also a gap of 10 years for my past CLP. So please do forgive me if I'm not really familiar with your syllabus, yeah? Okay, so okay, let me admit 3 more students. Okay, I've prepared some slides. Okay, let me share my screen. Okay. All right, so okay. Okay, so for past year questions, okay, we'll look at the year of 2021. Okay, question 2B. Okay, Peter obtained a judgment against Daniel in the sum of 1.2 million ringgit Malaysia in the High Court. Okay, so Daniel has failed to settle the judgment sum. Daniel is the registered proprietor of a vacant bungalow which is free from encumbrances. Describe the procedure which Peter can adopt to enforce the judgment against Daniel in respect of the said bungalows. So for these questions, okay. Okay, so these particular questions would actually take up 9 marks. Okay. So what are the methods of enforcement against immovable property? Because they have mentioned that it is a bungalow. Okay, so we'll actually zoom in into the immovable property parts. Okay, the first method will be the writ of possession, which is covered under the Order 45, Rule 3 of the Rules of Court. So writ of possession actually allows you to possess the property itself. That means the plaintiff can take possessions of the defendant's property. Okay, but for this particular method, you must actually obtain the leave of court before the court can issue out the order itself. So for High Court, it is under Form 87, and subordinate courts is 87A. Okay. So for writ of possession, okay, this is the sample of the writ. You have to address it to the sheriff of the court, whereby you have to set out your judgment itself, okay? When is the date of the judgment, okay? And also the name of the defendant, name of the plaintiff, and also describe where is the property being involved, okay? So you have to put in the details of the property, the title number, the address, okay? So, okay, you have to put in the amount being awarded in the judgment itself and also the cost. So you file in your writ and apply for the court order itself, okay? Okay, the next one will be the prohibitory order. Okay, prohibitory order is governed under Order 47, Rule 6 of the ROC. And how do you apply for a prohibitory order itself? Okay, you have to file in your notice of applications. Okay, and also supported by an affidavit. Okay, once you file in your notice of applications, when you extract the sealed copy, they will provide a hearing date itself. Okay, during the hearing date, you just appear in court and they will allow for the PO to be granted. The order will be granted itself. Okay, once you get the sealed PO, okay, you get a sealed PO and you have to serve it, register it with the land office itself. Okay, and the land office registered must be the land office depending on where the bungalow is located. Okay, for example, your case is actually being commenced in Johor Bahru, okay, but the bungalow itself is in Selangor. So you have to actually register the PO in the land registry in Selangor, not the Johor Bahru land registry, okay? After you have registered the PO with the land office, you have to file another notice of application for an order of sale, okay? This is governed under National Land Code, Section 256 and also Section 335, all right? So when you file in for an application for an order for sale, okay, they will actually fix another hearing date and to hear your application for the order for sale, all right? After the order was being granted, the court will actually set the auction date and appoint the auctioneer. Okay, and on the auction date itself, they will held whether the auction is successful. All right. Okay, so you might question actually, what if the auction is not successful? Okay, so Peter can actually reapply for another order for sale, but there will be a reduction in price itself. Usually in practice, they will reduce a 10% from the reserve price. Okay, so what if the PO lapse before the auction is successful? So it might actually drag. It might drag for a few weeks, few months. So you need to pay attention to the PO itself. Okay, so if let's say the PO is going to lapse before you can actually auction off the property, you need to apply under Order 47, Rule 6, Sub G. All right, and you might want to look at the case of Ban Hin Lee, whereby it was clear cut that the PO doesn't grant an interest to Peter. It doesn't grant the Peter an interest in the land itself. Okay. So we move on to the next question. Okay, question 2C. Okay, this will carry 8 marks. Okay, on 5th of January 2015, Pawan obtained a judgment in the magistrate's court against David for the sum of 50,000. Before Pawan could file execution proceedings, David left Malaysia for an unknown destination. On 25th February 2021, David returned to Malaysia as a successful businessman. Pawan wants to file a writ of seizure and sale in respect of David's movable assets in his residence. So advise Pawan on the procedure he should adopt before he can file a writ of seizure and sale under these circumstances and the principles applied. Okay, for this particular question, it is very clear-cut that they are going to question you on the limitation period. All right. So you can see that the judgment date, okay, 2015, 5th of January. All right. And when David returned to Malaysia, already passed 6 years. Okay. So the first thing will be the Limitation Act issue. Okay. Then on the writ of seizure and sale. So for this particular question, it carries 8 marks. All right.
Christy can help to unmute them. Mute them.
Oh, okay.
Participant, you go participants and then mute all.
All, okay. 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 So we have identified the issues itself. All right. The enforcement is 6 years from the date of judgment. Okay. So can Pawan still proceed with the enforcement itself? And we'll look at what are the principles of law involved. Okay. So Section 6 of the Limitation Act, 1953, it does not allow enforcement after 12 years from the date of judgment. So we are still within time, actually. So, okay. But Pawan will be required to apply for leave of court under Order 46, Rule 2, Sub 1, Sub A of ROC, and you apply the case of Teo Chi Hing. Okay. So under Order 46, Rule 2, it says that a writ of execution to enforce a judgment may not be issued without leave of court when 6 years or more have lapsed since the date of judgment or order. Okay. So how do you make an application for leave of court when the execution of judgment is more than 6 years? Okay, you need to file a notice of application, which is an ex parte application, and you have to file in together with your affidavit in support. Okay, so what are the contents of the affidavit itself? Okay, first you have to identify the judgment itself. Okay, when was the date and what is the cause of action? You have to briefly tell the judge. Okay, and what is the amount due as of date? Because when you obtain a judgment, in practice, usually it comes together with the cost and also the interest involved. So you need to identify in your affidavit in support what is the amount due when, as of date, when you file this particular application itself. Okay, and you need to explain what are the reasons for the delay in enforcing the judgment itself. You have to explain that because David was out of Malaysia, you can't even locate him and you can't do anything to enforce the judgment itself. Okay, so when David have returned to Malaysia after the 6 years from the judgment, now you are filing these particular applications. Okay, so you actually have to put in more facts regarding the merits of the application itself, whereby if let's say you have the details of David's assets, then you can put it in your application itself. Okay. All right, so this is the sample in Form 88 of the ROC itself, whereby you can look at this particular form. Okay, title, you have to put in the title itself. Okay, and that all the parties concerned attend before the judge or registrar in chambers on which particular date. You just leave it blank. They will put in here when you extract the notice itself. Okay, for this application of part judgment, you have to put in the judgment date itself and also the issues involved. Okay, the writ of seizure and sale. Okay, as our case against the defendant on the judgment dated when. Okay, notwithstanding that 6 years have elapsed since such judgment and that the defendant, David, do pay the cost of this application. Okay, then the registrar will put the seal here. Okay, this is the sample. Okay, so usually when you have good merits in your application, the judge wouldn't refuse your application. Once you have obtained the leave of court, then you can proceed with the writ of seizure and seal. Okay, so for writ of seizure and seal, we are going for order 45 rule 1 sub 1 sub 8. Okay, this is for any judgment for the payment of money. And also, okay, for movable property, we are going for Form 84. Okay, so what is the procedure for writ of seizure and seal? Okay, you have to file in your writ, okay, together with a precipice. Okay, and you have to deposit 1,000 ringgit in court, so that when you extract your writ and your precipice, you will get an appointment of bailiff by the court. Okay, and they will give a date itself for the writ of seizure and seal to be executed. Okay, on that particular day, usually what will happen is you need to fetch the bailiff from the court to that particular address. Okay, the bailiff will then enter the property itself. Okay, when they enter the property itself, they will start to organize what are the property that are seizable. Okay, usually like machineries, when we go to like some project sites or whatever, we will seize like some huge machineries, all the computers, tables, chairs, all the movable property are seizable. But of course, there are exceptions to it, and we'll discuss later on. Okay, once the items are being seized, the bailiff will actually list down all the items. Okay, and what the plaintiff need to do is that usually you need a security guard. Okay, you will need a third-party company or security company. Okay, you need a security guard to actually safeguard all the property that was being seized. Okay, and after they have a listing, okay, the defender will need to sign on the listing itself, all right, to make sure that all the properties are listed accordance to what we have seized. Okay, so they will then have an auction date and they will auction off the property. Okay, and hopefully the items that was being auctioned are good enough to settle the judgment sum, hopefully, but that was not always the case. Yeah. Okay, this is a sample of Form 84, okay, a writ of seizure and seal. Okay, you can have a look. It's actually quite long. Okay, this is part 1, okay, whereby the registrar will then put a seal here. Okay, and this is what you need to fill in. Okay, this is the part 2. Okay, and this is part 3. Usually this part will be filled in by the bailiff later on. Okay. All right, we move on to another question in year 2022. Okay, question 5B. Okay, the plaintiff obtained final judgment against the defendant for the sum of 50,000 in June 2016. The plaintiff was unable to enforce the judgment as the defendant went into hiding. So sometime in July 2022, the plaintiff managed to discover the whereabouts of the defendant, who now rents a shop unit to operate a mini market. So advise the plaintiff on the procedure to be adopted to enforce the judgment against the defendant. So this will carry 10 marks, yeah? So again, what is the issue here? Okay, the issue will be 6 years. Okay, so it's the same discussion just now. Okay, we have mentioned that Section 6 of the Limitation Act, okay, enforcement after 6 years. Okay, explain briefly the procedure that we need to obtain the leave from the court and what are the principles and the procedures being applied. Okay, so second issue will be the types of enforcement available for the plaintiff. Okay, on the facts itself, it was stated that he rents a shop unit for the operation of mini market, and also some facts which are not mentioned in the question that we can assume from the facts itself. Okay. The first one I will suggest is regarding the garnishi proceedings. Okay. Why are we going for garnishi? Okay, garnishi is for those against a third party where we know that like bank accounts or deposits. Okay, so from the facts itself, they have mentioned that the defendant is renting a shop unit. Okay, that means they have a rental deposit being deposited with the owner of the property itself. So with Order 49 of the Rules of Court 2012, the plaintiff can attach the debts owed by the JD, owed to the JD by any third party. Okay, that means we can actually obtain a court order for the third party. That means in this particular case, the owner of the property itself to release the amount directly to the plaintiff. Okay, usually for garnishi proceedings, we are doing it mostly for bank accounts. Okay, in practice, bank accounts, deposits, or any contracting parties. Okay. How do we file an garnishi proceedings? Okay, it will be by way of notice of application supported by affidavit in support. All right. Now we'll look at how the garnishi works. Okay, the process itself is quite simple. Okay, first you need to file in the notice of application, ex parte. Okay, supported by affidavit in support. Okay, then you proceed to a hearing of the application to obtain a show cause order. Okay, once you obtain the show cause order, you need to serve the order against the garnishi and also the defendant himself. Okay, they will then fix a hearing for the garnishi to show cause. Okay, on the hearing of the show cause order, okay, garnishi will need to appear and the court will grant the absolute order. Okay, once you get the absolute order, you need to serve again on the garnishi. Okay, after the service, then the garnishi will release the amount. Okay, so this is the sample of the show cause order. Okay, upon the application, reading the affidavit will actually affirm. Okay, so this is actually order for the show cause order for the garnishi to attend on the hearing itself. Okay, so this is the sample of the affidavit in support. Okay, so usually it will be shown by the judgment creditor. If let's say the judgment creditor is a Sendirian Berhad company, so you will need the director of the company to swear the affidavit. Okay. All right. So, okay, when we talk about the affidavit itself, when we talk about the affidavit in support by the judgment creditor, okay, how do you prove to the court that you have merits in your application? Okay, usually for bank accounts. For bank accounts, we need to exhibit in your affidavit that how do you actually obtain the bank account itself? Either by previous dealings or there is any previous payments from the judgment debtor. Okay, if let's say you have actually encountered in a case where you doesn't have any knowledge of the bank accounts that was held by the judgment debtor, can you actually file in a general application to the court? Okay, let's say you put in RHB Bank, Hong Leong Bank, Maybank, CIMB, all the banks you have put in. Will the court actually grant the order? The answer? Anyone? Anyone in the chat room? Can you just file a... Okay, yeah, Paul, Mr. Paul. Yes, no, the answer is no. Yeah, you can't actually file in a general application for garnishi proceedings. Okay. you will need to actually exhibit how you obtain the proof to the court. Because if let's say your exhibit shows that this is not actually a previous dealings, okay, the evidence obtained was actually illegal, the court will not grant the show cause order itself. Okay. All right. Okay. So regarding the service of the show cause order, just now we have mentioned that it must be served to the garnishee by way of personal service and must be at least 7 days before the hearing of the show cause order itself. Okay, so what about the judgment debtor? Do you need to serve it to the judgment debtor? It depends. It actually depends. Okay, if let's say it's a final judgment, as in our question, yes, we need to serve to judgment debtor. Okay, you must actually show to the court by filing the affidavit penyampaian, affidavit of service, that you have actually served first to the garnishee, when was the date, the timing, and enclose the copy of acknowledgement, all right, as an exhibit. Okay, second thing that you have to file is that affidavit of service that you have actually served to the judgment debtor. Okay, and the same thing is that you have to exhibit the acknowledgement itself. Okay. But what if your judgment is not the final judgment, is a judgment in default of appearance? Okay, that means you can't actually get into contact with the judgment debtor. Let's say, for example, your judgment in default of appearance is obtained by way of SS application. That means this debtor was totally unknown. You are not sure where is it. So how do you serve? How do you prove to the court for the service against the judgment debtor? Okay, the answer is that you can actually ask for the permission of the court to exempt the service to the judgment debtor. Okay, usually the court will allow it with your merits in your application. Okay. So back to our question, okay, when you have a final judgment, the defendant is there. Okay, when you serve the show cause order, who should you serve first? At the same time or how? Okay, in practice, what we do is we serve the show cause order first to the garnishee. Okay, we don't serve it to the judgment debtor first. Okay, we serve it to the garnishee. Okay, on that particular time and date itself, we have to make sure that the bank accounts were frozen. That means there will be no more transaction in and out for this particular account. Okay. Once we get the confirmation from the bank, then we serve it to the judgment debtor. Okay. This is actually a trick, because if let's say you serve it to the judgment debtor first or at the same time itself, the judgment debtor, what they will do is they will withdraw all the money from their accounts. Okay, so we are left with nothing. What we do is that we serve to the garnishee. Okay, after a few days, then we serve to the judgment debtor. That is to secure the money itself. All right. Okay, what will happen during the show cause order? That means the second hearing for the garnishee applications. Okay. By right, all the parties need to appear. That means the garnishee have to appear, the judgment debtor have to be in court. Okay, but for the current practice of the banks, what they do is they will actually not be sending any of the officers to the court. Okay, what they will do is that they will write into the plaintiff's lawyer. Okay, and saying that, okay, we have received your show cause order and we have frozen the particular bank accounts for how much of ringgit Malaysia, and we'll hold on until we receive the absolute order. Okay, so on this particular date, the second hearing date, we will not be appearing to the court, and kindly mention on our behalf. So from this letter itself, we need to do the e-filing to the court, and on the date itself, we will need to inform the court saying that we are actually mentioning on behalf of the bank, of the garnishee. Okay. Okay, so if let's say garnishee do not appear, okay, what can you do? First, either you withdraw the application or you proceed with your application and obtain the next hearing date. Okay, and after obtaining the next hearing date, you have to serve the hearing date itself by a cover letter to the bank again, informing them, okay, this is the next hearing date and your attendance is compulsory. Okay, you have to make such an service to the bank itself. Okay, so what if the judgment debtor fail to appear? It's okay. If let's say the garnishee is there, judgment debtor was not there, it's all right. It doesn't affect your application. Okay. Another question would be whether garnishee can actually seek for costs. The answer is yes. Usually, if let's say the bank did send some officer or they actually appoint a lawyer, okay, they can actually ask for costs. 200, 300, a transport cost. Okay, they can ask for it. So what will happen to the frozen amount of the money? Okay, first they will actually pay out the cost to the garnishee. That will be the first priority. Okay, then only they will cover the judgment sum. All right. So outcome of the second hearing, order was granted. Okay, either sufficient to cover the judgment sum, we are not sure. Okay. And second, when the order was dismissed or stayed. All right. So if let's say the order was granted against the garnishee, okay, the plaintiff will need to proceed to extract the garnishee order absolute, okay, and serve the order against the garnishee. All right. So the garnishee will then release the amount awarded to the JC or their solicitors. Okay. Okay. What if, okay, the amount are being disputed by JD, okay, or there is a setting aside application or stay of execution being filed for this particular case. Okay, in what situation when there will be amount being disputed by JD? I don't think it's applicable in our question, okay, but just a further discussion, okay. So if let's say the JD are disputing the amount itself, in what situation? It will be in a situation where it is not a final judgment. It is a judgment in default being obtained. Okay. So the judgment debtor can actually dispute the amount itself. Okay. What they can do is they will file a stay application against your garnishee. Okay. Against your garnishee proceedings. Okay. At the same time, they will file a setting aside application against your JID. All right. So while there is a stay application being filed and a setting aside application being filed, in practice, the court will not proceed with your garnishee hearing itself. And they will not grant the order. They will not grant the absolute order. Okay. So in the meantime, the case will be sent back to dispute on the setting aside application. Okay. Whether your service of the writ is a proper service or there is any merits in the application in setting aside, okay, or any merits in the defense itself, okay. I'm sure that that will be covered in another topic. All right. So your garnishee application will be stayed until they have disposed of your setting aside application. All right. So if let's say the setting aside application is not successful, all right, your GID still stands, all right, they can proceed with your garnishee application, all right. But if let's say they manage to set aside your JID, all right, that means your JID is not a judgment anymore. So your garnishee application have to be withdrawn, yeah? You have to remember about this because some of the lawyers, they just focus on the setting aside application and they forgot about the garnishee application that was being stayed, all right? So once the JID being set aside, you have to remember to withdraw your garnishee application, all right? Okay. when there is an appeal by the JD, okay? Usually, if let's say for a final judgment after trial, after submission, plaintiff have won the case, okay? And they have filed for a garnishee application. And while the garnishee application is being heard, the JD file an appeal to the higher court, okay? So they will definitely file a stay of execution against your garnishee, okay? But I'm sure that you all are familiar. For monetary claim, stay of execution doesn't apply, okay? Because we are not touching on any immovable property. So usually you won't be able to success in your stay of execution for garnishee, all right? Okay, what are the next type of enforcement against this particular judgment debtor? Okay, usually we call it as JDS. Okay, this is under Order 48 of the Rules of Court, whereby the judgment creditor can actually apply to the court to examine the debtor itself. Okay, this can be done for the production of the books or documentation by the judgment debtor. Okay, and the method of application will be by way of notice of application, ex parte, and also affidavit in support. Okay. So this is an sample for the affidavit. Okay. You might realize that in this particular affidavit, this is not sworn by the judgment creditor. Okay. This is actually affirmed by the plaintiff solicitors. All right. So the application is made by the lawyer itself. Okay. So once the order was being granted by the court, this is the order itself, Form 96. Okay. You can have a look. Okay, this is the sample. Okay, other than a garnishee proceedings and also a JDS application, another alternative that you might want to argue in your answer will be the issue of WSS, okay? Because they have actually mentioned that he operates a mini market, okay? A mini market definitely have goods, all right? So can you apply for a writ of seizure and sale against the goods in the mini market itself? Okay, this is actually, I will say that is a trick. It's a trick in your question itself. Okay, because for WSS, we have exemption for things that we can't seize. Okay, if you look at Section 3 of the Debtors Act, okay, these are the exemption itself. Okay, you can't seize apparel, cooking utensils, bedding, tools of trade, the account books, pension, gratuity, or allowance by the government. So if let's say, according to the question, is goods in mini market, can we say that is a tools of trade for this particular judgment debtor? Okay. So if let's say your answer is going to proceed with yes, is a tools of trade, then you can't proceed with writ of seizure and sale. But if you are saying that the goods are not the tools of trade, okay, then you are going to proceed with the discussion of the writ of seizure and sale, and the procedure itself, the bailiff to seize the goods and proceed with the auction to settle the outstanding amount. Okay, so this is actually open up for argument. Okay, so as lawyers, you need to focus on the facts itself, okay, and put on your argument. You can argue that yes, it's tools of trade, or I don't know. Okay, there is no wrong answer to each question. Okay, as long as you are within the ambit of the question itself, okay, you are open for discussion. You can put on your argument. Why do you think that is a tools of trade, and why do you think that is not? Okay, so I believe that the examiner will not penalize you for giving your argument, okay, as long as your argument is within the ambit of writ of seizure and seal, okay, and not to be covered to the topic of like amendment of pleadings or whatever, okay. As long as you are within the topic itself, you are safe. You can put in your argument, all right? Okay, just now we have mentioned about the JDS, okay? This is just another issue that I would like to discuss further. Okay, this might not be relevant to this particular question, okay? So, because why do I say so? Because it's only 10 marks, okay? You are not going to spend like the whole time going for this particular question, which only carry 10 marks, okay? So committal proceedings, if let's say this year you have a question that carries like 20 marks for execution, then you might consider writing for committal proceedings, okay? Committal proceedings is actually covered under Order 45, Rule 5 of the ROC. This is where the judgment will require an act to be done. Okay, so if let's say the judgment debtor failed to perform, then we can file in an application to move the court for an order of committal. Okay, so this is usually what happened in case of JDS. When we serve the summon itself, they fail to appear. They fail to appear to court for the oral examination. Okay, and for committal proceedings, you need the leave of court. Okay, and the order itself must be personally served on the JD, the judgment debtor. Okay, so just a short discussion. Okay, all right. Okay, we have finished with two past year questions. All right, let me see whether there is any. Okay, there are some questions here. Okay, let me stop sharing the slides. Okay, let me look at the question first. Okay, from Cindy. Cindy asked whether the methods mentioned just now apply to property without title. Do you mean property without individual title but only have master title? Yes. Okay, it doesn't matter whether the property have individual title or master title, as long as you can identify that this particular property, it belongs to the judgment debtor, that is sufficient enough, all right? So you can proceed with your application. Okay, a question, when we should apply for, sorry. When we should apply for writ of possession and writ of seizure and seal. Okay, Dr. Chi have explained in the exam, better go for writ of seizure and seal. Writ of possession if JAC wants the property. Yes, correct. Okay, because for writ of possession, in practice, what do we do? Usually, you will need to appoint a bailiff to collect the rental. Okay, it doesn't mean that, okay, for writ of possession, it doesn't give you the right to sell. It gives you the right to possess the property itself. Okay, once you possess the property, okay, you appoint a bailiff, you rent the property out, and you collect the rental to satisfy your judgment sum. Okay, writ of seizure and sale is different. Writ of seizure and sale is when you get the order from the court to sell off the property, and from the purchase price itself, it covers your judgment sum. So this is totally different thing, yeah? Okay. Okay, from Cindy, does previous dealings mentioned just now means using previous transactions that the debtor has paid the creditor progressively but now the debtor has stopped paying to show that the debt owed to the creditor. Yes, correct, Cindy. Yes. That means if let's say previously there are transactions by internet banking, all right, you can show the slip, the transaction slip, or there is a image of the check itself. The image of the check is good because what we do in practice, okay, once we get the image of the check, you can actually see which branch is, let's say, for example, Hong Leong Bank, okay? And you need to bear in mind in practice is very crucial because sometimes we have Islamic banking, okay? Maybank and Maybank Islamic is totally different entity. So if let's say you doesn't have the image of the check, you are not sure whether it is Maybank or Maybank Islamic. But once you get the image of the check itself, it's very clear cut. Okay, which bank, Hong Leong or Hong Leong Islamic, and which branch, Seremban, Port Dickson, which branch. Okay, so you can actually identify the branch, the bank, and also sometimes the account number is stated down there. Okay, so it's a very important point to get previous checks from the client. Yeah, sometimes if let's say the client doesn't possess it, but they remember that they have paid through the checks, so they can actually write into the bank to get the previous image. Okay. Farhan asked whether does it include ship trading? Ship trading ship? What does it mean, Farhan? All right, we move on to the next question. Yeah, Farhan, you can clarify it in the chat group, yeah? Okay, does it any difference between sheriff and bailiff? No, sheriff and bailiff actually refers to the same officer, yeah? Okay. Equitable execution for profit, because she ran a mini market, will make profit. Usually you can't get an execution for profit itself. It's very difficult, okay, because it's an uncertain amount, okay. So we wouldn't advise on execution against the profit itself, okay. All right. Rid of distress. Saraswati, rid of distress. Anything? Okay, Farhan. Yeah, you're here. Okay, does trading ship, will it be able to cease through writ of seizure and sale? Okay, for ship trading and you are going against the writ of seizure and sale, it depends where is the ship. Okay, if let's say you can identify where this particular ship is and it belongs to the judgment debtor, yes, you can bring the bailiff there. Okay, they can seize the ship itself. All right. Okay, any more questions?
Any further question can ask my master.
I guess everyone is very familiar with enforcement of judgment.
Or you guys have any other civil question also can ask. Yeah, because my master is mainly focusing on civil litigation.
No more question? Okay. Yep. Okay. How about if JD has stock and shares? Stock and shares, yes, you can actually file for garnishee. Okay. Briefly, discovery order 24. Okay. For order 24, what discovery do you mean? Okay. Against who? Against a third party or against the defendant or against the plaintiff? Okay. For discovery, okay, Dr. Chi, do you want to cover?
Discovery, discovery, like one student asked also, there's actually two type lah.
Yeah.
One is the pre-trial discovery or the interlocutory application for discovery. The pre-trial discovery is provided in Order 24 Rule 7A. That means to say before an so-called civil action commence, one party can go by originating summon or as plus affidavit to ask for certain types of documents in the hands of possible defendants, possible now, because the top officer sometimes could not be identified. This is how we use. And Order 24, when you use it during interlocutory application, that means during the trial, after you have receiving the statement of claim, you find the other parties find the statement of defense. If you want to take a look at the specific document, usually discovery order is towards specific documents, you must ask, okay, I want this contract, I want this invoice, so something like that. So you go for Order 24 Rule 3. Okay, and it is subjected to a few rules. You cannot simply just ask from the other side for any other documents, because you cannot fish for evidence, you must base on whatever you need, then you ask. And it is subjected to necessity as well as your relevancy rules. So the documents must be helpful and also relevant to your current case. Only you can ask for that documents. Okay, so not too hard. A lot of people they confuse discovery with I think further and better particulars. They're quite confused with that. So don't get confused. This further and better particulars is in regards to the pleading itself. Either you are confused with whatever they have told in the statement of claim or statement of defense, then you seek for clarification. Whereby Order 24 is like you go through by your notice of application with affidavit to ask for specific documents. Okay?
Okay, thank you, Dr. Chi.
No, 7A is the X is still very confused. 7A is pre-trial application. It's just like a codified version of your Norwich Pharmaca order, NPO. If you do not know who is the top officer, you are not sure which party is involved, then you file OS plus affidavit to check the documents. For example, one hospital, okay? Take for example, your client approached you because his wife died in the hospital. So you have no medical report, you have nothing, you just got to know one particular information. His wife died in the hospital. So you need to make pre-trial discovery. You need to identify who are the doctors involved, who are the nurses involved, okay? Correct or not? Which departments involved? So you file Order 24 Rule 7A by the way of OS plus affidavit. That means court will give one order. Hospital, for example, Hospital Sultana Amina will need to let you have access towards the medical record. Okay, you get me? Or still confused? Something like that. Rule 7, I think, is for particular documents, specific documents. Let me check my
Order 24.
Order 24, Rule 7. Mm. Yes.
Order 24 Rule 7 is for the parties in the proceedings itself. And
Yeah,
for
particular.
7A is against another person.
For identity of tort feasors law. Yes, yes. Order 24 Rule 7, I think it's very specific order, is to identify certain documents, like I want this particular invoice that took place on, for example, 12th of June 2023. There's a transaction, the people issue documents, correct, you're right, X particular documents. But order 3 is a more general order. I think a few questions coming in.
Yep. Cindy asked whether can the methods used to ascertain what JD have be used to identify the debt owed via Ganeshi. Okay, Cindy, what you mean is that we questioned him on JDS and later on we proceed with Ganeshi, right? Yes, correct. You can do it. Okay. Okay. Can I get a clarification between Order 14 and Order 81? Order 81 is regarding the proceedings in land. Okay. For this, right, if not mistaken, okay, Order 14, you can only do it once the defendant enter the appearance. Okay, but Order 81, it doesn't matter whether the defendant have entered appearance or not. Okay. So, but if let's say for the affidavit part, right? The affidavit for order 14, okay, it might be verified by the plaintiff or their solicitors, but if let's say for order 81, you can't verify by the lawyer, okay? It must be verified by the plaintiff itself. Okay. Isn't it by charging order for stocks and shares? Yes, you can. You can actually go by charging order also. Okay. Can you explain again the difference between Rule 7 and Rule 7A? Okay. Rule 7 usually is for where the parties are involved in the proceeding itself. Okay. That means they have already identified the parties. Okay. But for 7A is against any other person. All right. Okay, Rachel asks, is discovery like when you need more evidence and FPMP, more info? You need more evidence than you file for discovery, but discovery proceedings, you must not use it as fishing tools, Yeah. So when you file for discovery, whether the judge will grant it or not, it depends. It depends on the facts of your applications. So if let's say you draft your affidavit in a way that is so clear that you are fishing for documents, of course the court doesn't grant it. Okay. Okay, Rule 3 and Rule 7 is the same thing. So for identity, just must go under Rule 7A, right? So for Rule 7, only documents, right? Yes, correct. Okay, from Hila. Will Order 31 of ROC be any of relevance for execution of judgment specifically for WSS? Okay, Order 31. Sale of immovable property. Yes. If let's say you can actually get the details of the property itself, then it will be helpful for your execution part. Yeah. Order 7 Rule 2. Order 7 Rule 2. Farhan.
Relevant is setting to apply for specific. So,
Mm-hmm. Wayan, hi, I will just like some clarification. In a case originated from magistrate court, what is the next court of appeal and the apex court for appeal? I was reading the SCA and CJA and noticed that Sessions Court does not have appellate jurisdiction. Does this means that a decision from the magistrate is appealed to the High Court, skipping the Sessions Court? Then will this affect the two-tier appeal? Okay, for magistrate, you are appealing to High Court. That is correct. You doesn't go to the Sessions Court. So that is your first appeal. Okay. From the High Court, if let's say you are going to appeal again, is going to be Court of Appeal. Okay. Yeah. So skipping the Sessions Court, yes. Because usually for appellate matter, High Court will be hearing it. Okay. But bearing in mind that if let's say your case originate from magistrate court to appeal to High Court, what is the conditions? Okay, you have to double check on that because if not mistaken, when your monetary claim is up to certain
10K.
amount, 10,000, if not mistaken, 10K, yeah, so you can't appeal. All right, so it depends on the facts itself. Okay, Rule 3 for document and identity. Dr. Chi have answered. Usually discovery is for documents, not seek to get the identity. From the document discovered, you identify the defendants. Okay. Yeah. So may I know when would be when would it be relevant in an exam setting to apply Rule 14A or the 81? For example, is there any specific circumstances they are expecting their argument? 14A and order 81. Example, Dr. Chi, example.
14A usually is disposal, issue of law disposal. Meaning, if you have a contract, for example, I and Christy have a contract, but we have argument about the clause. Okay, take for example, we get sued. We get sued, and there's an internal partnership between us. Take for example, this one. Okay, and then we were found liable. So how much percent should I pay? So we have query with this sort of clause. Then we know in between me and Christy how to divide the liability. And then we go for order 14A by OS so that the court can construct and give interpretation to this partnership agreement, and then to dispose the issues, the dispute between me and Christy faster. You get what I mean? So this is disposal by way of law. Okay? Order 81, on the other hand, I think it's for equitable relief, That one is for specific performance or that. That one is also a summary judgment. Yeah. Specific performance, rescission, or return of deposit. Let's say, for example, I wanted to rent a house, then subsequently I forfeited. So can I get back the deposit? Something like that. Then you go for order 81. That one is just like the faster way for court to dispose the matter without going through the full trial. Can you understand? Mm.
Okay, so how about order 33 and order 14A? Sometimes confused. Okay, Dr. Chi have explained order 33 against order 14A sometimes could be used interchangeably to dispose
Mm.
issue of law. Okay, but for issue of facts plus law, order 33 will be better. Okay,
Mm.
so patient. Sorry, I'm still confused when to use order 24 rule 7 or order 24 rule 7A or order 24 rule 10. Yeah, Dr. Chi, you might need to explain one more time on the issue of discovery.
Order 24, Rule 10, I have never used before. Rule 7, particular documents you want to discover is a specific type of order whereby you want to discover a certain type of documents that you think will be helpful to your case, in which manner it is relevant and necessary for this discovery to take place. Whereby the Order 24 Rule 7A is pre-trial discovery against any other people. That person may not be your possible defendant, but you make this so-called discovery process. The good example would be hospital. The example that I've told you, your client approach you, his wife died, and then you don't know who are the top officers, you don't know who are doctors, nurses, which departments involved. You want to get access to that bundle of medical records, So you have to investigate like Sherlock Holmes in order to find out who is the top officers. That's why you use Order 24 Rule 7A to get all the defendants to be named in your read. So this is how it plays. Just like account documents. Account, I think cannot pull out, Account,
No, I don't think so. I don't think you can
yeah.
ask for the discovery order against accounts documents. Yeah.
Hmm.
Only income tax can do so.
Hmm. I think account document is protected under Financial Act, something like that.
Mm.
SMU does not disclose if their clients behave fraudulently, right? Even if they are not a party to the proceedings. Uh,
For both
uh,
particulars is very difficult.
mm,
Mm.
mm. Okay, you all must understand the rules of court itself is just a procedural rules, So some institution like financial institution, especially this bank, all that, or insurance company, for example, they can have the right to withhold their documents so not every parties that we can get discovery order.
Mm.
But the one I'm pretty sure is hospital. Hospital, surely we can get. They're not protected by Medical Act. Mm. Let's see parties. Any other question?
For medical issue, recognize the hospital is insufficient does not mean the hospital is a party as well. Okay, patient. Usually, we don't only name the hospital. We name the doctors, the nurse in charge. We name everyone who have been in contact with the patient. Yeah, that's why we need some reports who actually signed, who actually attended. So we name all the parties there. Okay. Yes.
Any other question?
Mm. Hospital will be vicariously liable.
Mm.
Yeah.
Mm. But it's very important for you guys to be very familiarized with the rules of court in order to sit for your exam? For the
Order 24 Rule 10.
Oh.
Documents which parties file affidavit in support and other parties requesting origin. Is it the station order?
I think it's the documents relied by the parties in their pleading and also affidavit lah. Then you want to examine it.
Yeah, it's examination for the original documents.
Any other further question?
Okay. Any more questions?
Any more question? Otherwise, we'll call.
Is okay, from Cindy. Is Order 14A commonly used in practice? It seems like high threshold to cross. Question can be determined without a full trial. Yes. Actually, for Order 15, Order 18 striking out applications, the threshold is very, very high. The reason to it why for those interlocutory proceedings, the threshold is higher is because, when you have an applications, okay, you strike out the writ summon and statement of claim, for example, okay, if they allow the striking out, and the plaintiff appeal, all right, first, the judge have to write a grounds of judgment for the striking out application, all right, when they go for appeal, and the case being revert back to the original court, he have to hear the case again. So it's actually double work. So once you file a striking out and all this, right, they actually don't allow. They don't allow, and they will ask you to go for a full trial and go for submission and everything, and they will give a final judgment. That is the reason for practice. Okay.
Okay. Then we wait another 2 minutes. If there's no further question, then we should end our session.
Okay.
Please feel free to ask when you still can.
Yeah. Okay, thank you, Guna. Rachel asked, how did you survive CLP? My CLP was 10 years ago. Yes, I started my chambering in 2012. Yeah, that was 10 years ago. But I realized that the question is more tricky and more complicated comparing to my years. Seriously. I still have the ATC notes from Mr. Joseph.
Yeah, I saw it. I'm the witness for that. Okay, but I think that is the way to go through. Okay. Then we shall end our session now, Christy. Thank you so much.
Okay.
Thank you so
All
much.
right, thank you.
Thank
Thank
you.
you.
Off the recording. Thank you. Thank you.
Thank
so much,
you.
Christy.
Thank you, everyone.
Thank you.